Well, welcome to everybody. One moment. Thank you to all of you for coming, for attending this webinar um, about the new family law, realities and future perspectives. Um, well, traditionally, the concept of family has been identified with the nuclear family based on the concurrence in the parents of the characteristics of duality. So that is two people with different roles, father and a mother, um, marriage and heterosexuality. However, the evolution of society has been manifesting the appearance of successive alternative forms of family units to the point that doctrine currently advocates speaking of families in the plural rather than of family in the singular. Furthermore, in today's world, families are increasingly affected by new realities such as digitalization, transgender families, surrogacy, and the arrival of migrants in Europe, among others. In this panorama of increasing family complexity, we can talk about a new family law on which we intend to shed some light in this webinar. Thus, we have excellent speakers who will talk to us about transgender parentage, the new families, the protection of children about digitalization and digital parenting in the first session of our webinar, and about civil liability in family law, protection of accompanied minor migrants in the EU, a critical view of the surrogacy laws in Denmark, and asylum and families in the second session. These two sessions will be directed by uh, two magnificent chairs, the co-chairs of the SIG, Elena Bargelli, who is a full professor at the University of Pisa, and Ilaria Pretelli, who is a researcher at the Swiss Comparative Institute, Comparative Law Institute. I am Francisco Javier Jimenez, and I'm a professor of civil law at the National Distance University, the Distance Education University in Spain, and I'm the third co-chair at the SIT, the Family and Succession Law SIT. We hope that the context of this webinar will be interesting to you and useful for your professional activity. And after this, let's hope a short presentation, introduction, we are going to start our webinar with the first session, which will be, as I have said, which will be chaired by Elena Bargelli. So, Elena,
Yes.
you have the floor.
Thank you very much, Francisco, for giving me the floor and also for organizing this webinar, which is the fourth the Family and Succession Law Special Interest Group has organized in 2024. The first one was organized by the University of Graz on succession law. The second one was organized by the University of Munich on extrajudicial administration of justice in family and succession matters. The third one was held on the occasion of the ELI annual conference in Dublin and focused on stepchildren. This is the fourth one and has a more a more general content. Welcome everybody also from my side, of course. I will give the floor to Professor Cristina Campiglio, who is Professor of International Law at the University of Pavia, and will present a speech on multiple and transgender parentage in cross-border families. Cristina, the floor is yours. Thank you very much for joining us.
Thank you for this invitation. Next slide, please. In a short, next slide, please. In the short time span of a couple of decades, family law is probably on the brink of a Copernican revolution. The principle that a child can only have a mother, female, and a father, man, has been overcome following significant societal, biomedical, and legal developments. We are witnessing a clear trend today towards legal recognition of multi-parentage and a timid opening towards transgender parentage. This trend finds its foundation in the individual, in the right of everyone to found a family, which combines in transgender cases with the individual right to self-determination. That is, in rights which are also protective at an international level. I refer to Article 8 of European Convention and Article 7 of the EU Fundamental Charter, which recognize the right to respect for private and family life. From a biological point of view, multi-parentage, specifically multi-maternity, presents itself in two hypotheses. The first one occurs when the oocyte belongs to a woman other than the pregnant woman. This is the case of heterologous fertilization if the oocyte belongs to a donor, or surrogacy if the oocyte belongs to the aspiring mother who commissions the pregnancy to others. Here, the child is genetically connected to one mother, but gestationally connected to another one. The second hypothesis is currently very rare and concerns situations in which the oocyte of the mother contain diseased mitochondria. To avoid the transmission of mitochondrial diseases, the oocytes from a donor possessing healthy mitochondria are used. So the baby has two genetic mothers, the mother who supplied both womb and egg nucleus, and a woman who supplied healthy mitochondria carrying normal mitochondrial genomes. This is the only case of genetically three-parental conception. Next slide, please. The divergence of states as to the subject who can access assisted reproductive technology and as to the legitimacy of surrogacy is hindering the adoption of international rules on filiation. The works started since 2011 by the Hague Conference on Private International Law with a view to the conclusion of an international convention on parentage surrogacy is now at a standstill. In the absence of international regulation, the so-called procreative tourism has developed over the years towards the most permissive states. Thus, for example, many heterosexual Italian couples went to Ukraine to find a surrogate mother. After the outbreak of the war with Russia, the destination became Cyprus, while male homosexual couples are forced to go overseas, Canada and the United States, to access surrogacy, which is also permitted for male couples. For female couples, the preferred destination is Spain, which allows access to heterologous fertilization regardless of sexual orientation. Obviously, once they return to their home country, the new parents ask for the recognition of their new status resulting from a public document or judgment, placing the national legal system in front of a dilemma to recognize these unknown forms of parenthood in the name of the right to the continuity of personal status validly acquired abroad, or instead to deny their effects in the name of the fundamental principles of the legal system, which requires the existence of a biological genetical link between parent and child. Next slide, please. The European Union is also dealing with the problems related to the recognition of parental status obtained abroad. In fact, the EU Commission presented in 2022 a proposal for a regulation on jurisdiction, applicable law, recognition of decision, and acceptance of authentic instruments in matters on parenthood, and on the creation of a European certificate of parenthood. The very prospect of this European certificate has provoked a reaction from some member states, including Italy and France, whose parliaments have expressed a negative position on the proposal. The situation in Brussels, as in The Hague, is therefore in a stalemate, for which it seems difficult to see a solution today, especially since the European Parliament in 2023 proposed to insert in the future regulation a recital according to which the EU regulation should ensure that children enjoy their rights and maintain their legal status in cross-border situation, I quote, without discrimination based on the formation of their family, and should cover the recognition in a member state of a parenthood established in another member state of a child with a same-sex parent, of a child with transgender parent, of the child with multi-parents. Next slide. As previously said, multi-parentage from biological point of view occurs today in the case of fertilization of the oocyte of a donor, one mother and two mothers. From a legal point of view, on the contrary, the principle of double parentage remains firm, one mother and one father. In recent years, however, as is known, a new form of parenting has emerged from a social point of view. Legal parents can be joined by one or more social parents. Even in Italy, where family law is very traditionalist, social parenting, that is, without genetic, biological, and gestational ties between the interest parties, is recognized by case law. Next slide, please. Focusing on the cross-border perspective, it is worth mentioning here an interesting decision made in 2023 by the Court of Milan regarding triple maternity, biological, adoptive, and social. The story can be summarized as follows. A German woman, through art, has 3 children as part of a shared parenting project with her wife, who subsequently adopts the children. The couple enters into crisis, and the woman begins a relationship with an Italian woman resident in Germany, who, from that moment on, regularly visits the children and also take care of them financially. For work reasons, the mother moves to Milan, with the children, and some time later denies any contact between them and the Italian partner, with whom she has broken off all relations. The latter starts a lawsuit in Milan asking to be able to visit the children on the basis of German law. Alternatively, she asks, on the basis of Italian law, for shared custody of the children. The court rules on the basis of the 1996 Hague Convention on parental responsibility. Also, the convention indicates in principle that the lex fori, id est the Italian one, is applicable. The court considers German law to be applicable since the convention itself allows, by way of exception, to resort to a law other than the lex fori, I quote, insofar as the protection of the person of the child so requires, and provided that with this other state the situation presents a close connection. In this case, German law that allows a person closely related to the minor to be judicially granted a right of access in the presence of a proven social family relationship and actual responsibility appears to be more protective than the Italian one that, in the event of family disagreements, recognize the children's right to maintain a balanced and continuous relationship only with each parent. In short, German law is more protective of the minor as it values de facto relationship more than de jure ones. It is therefore on the basis of German civil law that the Italian court recognizes the applicant's right to visit the minors, taking into account the consolidated social family relationship with her. Next slide. As anticipated at the beginning of my talk, the issues of the impact of gender reassignment on parenting has been raised in recent years. The German Federal Court has addressed it in two separate cases in 2017. The first decision concerned the appeal filed by a transsexual-born man whose partner has given birth to a child with the transsexual's sperm. He had been registered as the father. The mother was registered as the birth mother. The second decision concerned an opposite hypothesis, namely the appeal filed by a transsexual-born woman who had given birth to a child following fertilization with donor sperm. The court rejected both appeals. According to the German law on transsexualism of 1980, the original sex of the parent has been correctly reported on the birth certificates, and not, as required by the appellants, the new sex, female in the first case, male in the second. The interested parties then turned to the European Court of Human Rights, complaining of a violation of Article 8 of the European Convention. In 2023, the Strasbourg judges ruled in the sense of the conformity of both German decisions with Article 8 of the European Convention. Next slide. Worthy of mention is the case of an English woman who in 2013 began the process of transitioning to the male gender. Passport and records were amended to show the gender is as male. In 2016, he suspended testosterone treatment and later commenced fertility treatment. The aim of that treatment was to achieve the fertilization of one or more of his eggs in his womb. Records from the clinic showed that his gender was registered as male. In January 2017, he issued an application under the Gender Recognition Act 2004 to obtain a gender recognition certificate confirming that he was male. Then he gave birth to a son. He was informed that he would have to be registered as the child's mother. Also, the registration could be in his current male name. Thus began a dispute before the High Court of Justice Family Division aimed at obtaining registration as father, the gestational parent, or simply parent. The appeal was rejected. Next slide. Not very different is the position of French judges. The Toulouse Court of Appeal in 2022, in fact, held that a transgender woman who has retained her masculine attributes is legally declared as the mother of the child he had with her wife. Next slide. In 2018, the Council of Europe called on states to ensure that the gender identity of transgender parents is correctly recorded on their children's birth certificates. Thus, also in the face of the progressive spread of LGBTQ+ culture, an ever-increasing number of states are taking legislative initiatives in the field of recognition of non-binary identities and transgender parenting. Next slide. In Belgium, where the law that reforms the regime relating to transgender persons with regard to the mention of a change in the registration of sex in civil status documents and its effects has been in force since 2017. A specific circular has been published in 2023. This circular contains precise instruction for civil status officials, according to which a woman who becomes a man and gives birth is considered a mother in terms of affiliation and appears as mother on the birth certificates. A man who becomes a woman and conceives a child is considered a father in terms of affiliation, but appears as a co-parent on the birth certificates. In other cases, the new sex is taken into account, and the birth certificate mentions this person as mother, father, according to the new sex. Next slide. The Spanish law for the real and effective equality of trans people and for the guarantee of the right of LGBTQ+ people also dates back to 2023. A new provision is introduced in the law of civil registry, according to which in registered same-sex couples, references made to the mother shall be understood as referring to the mother or gestational parent, and references made to the parent should be understood as referring to the father or non-gestational parents. Therefore, the woman in gender transition who gives birth will be indicated as a mother, even if in the meantime she has become a man. Next slide, thank you. Germany has recently reformed the aforementioned 1980 law that considered the next of origin to be relevant. Not only if the birth takes place before the formal recognition of the sex change, but also when, as in above mentioned case decided in 2017 by the German Federal Court, conception or birth occurs after the sex requalification. Self-Determination Act 2024 provides that the sex can be indicated in various ways, male, female, different, or not indicated at all in the civil register. In birth certificates, only the father and the mother can be indicated as parents. The method of recognizing parenthood will be defined by the forthcoming reform of filiation. Next slide. Pending the approval of the reform, the Self-Determination Act provides for a transitional provision according to which, upon request of the interest party, in the birth certificate of the child born to a transgender person, the designation of a father or mother can be replaced by parent. Next slide. Next slide. As with multi-parentage, the problem of continuity of status across borders will soon arise for transgender parentage. It should be noted that it is a problem that the states will have to address not only from their respective national perspectives, but also from an international perspective, in compliance with Article 8 of European Convention, as extensively interpreted by the European Court, and from a European perspective. Next slide. The Court of Justice ruled last month that the EU law, read in the light of Article 7 of the Charter of Fundamental Rights in the European Union, precludes legislation of a member state that does not permit recognition and entry in the birth certificate of a national of that member state of a change of first name and gender identity lawful acquired in another member state when exercising the right to free movement and residence. It is a ruling in line with the case law relating to the recognition of the status of a spouse, child, parent acquired in another member state by virtue of institution, same-sex marriage, and parenthood in female homosexual couples unknown to the member state concerned. A similar position cannot be excluded in an hypothetical appeal relating to the recognition of the status of transgender parenthood. The last slide, please. This is a part of the judgment of the European the Court of Justice. Slide. Thank you. This recognition of the status of transgender parenthood would be in line with the aforementioned proposal of the European Parliament to provide in the future regulation on filiation the recognition of parenthood established in another member state of a child with a transgender parent and multi-parent. Thank you.
Thank you very much, Cristina. Quite interesting, I would say. Thank you for giving us this really interesting overview of the latest national laws on transgender parenthood and their impact on cross-border situations. Now The next speaker is Virginia Zambrano, a professor of comparative private law of the University of Salerno, who will speak about family and families between European law and convergence strategies.
Yes.
Virginia, the floor is yours. And thank you again for being here.
Good morning, everybody. I have some technical problem because I can hear a kind of return in my audio. I don't know.
No, we have no trouble in hearing you.
Okay, I will.
No, we are hearing you very good.
Yes.
Okay, then first of all, I would like to please and everyone. I am very grateful to Francisco, Elena, and all my colleagues. This is a very interesting meeting, and I'm really very pleased to be here again after the one of the last year. Well, I start. As I do not have a slide, so I beg your pardon, but as is well known, the process of family evolution started in Northwestern Europe starting from the 60s and spread by the 70s over Mediterranean shores as well. Yet the concept of family does not contain, this is my focus, a convergent and unambiguous legal definition. It reflects values, principles, and ideals of different human society, and it undergoes a slow and unavoidable transformation of its very essence. The transformation concerns gender roles. We have heard about that. Intergenerational relationship involving its forms, patriarchal, nuclear, parental family, and so on and so forth. Its structure, single parent families, extended families, reconstitutes families, and more generally, the different ways of making a family, i.e. marriage, heterosexual and homosexual cohabitation, civil unions, gender unions, religious bonds, and so on and so forth. In addition, we should consider the spread of a gender ideology and queer lifestyle which influence what family is or look like. Now, issues concerning the transnational dimension of the European family have, moreover, been amplified by the spread of various family models deeply connected to migration. Just to give you an idea, there is in Italy at the moment a very interesting debate generated by a case adjudicated by the Ancona Tribunal and regarding the registration on the civil status register of the municipality of Ancona to formalize in Italy the dissolution of a marriage celebrated in Bangladesh, which is quite interesting. It's a case law some weeks. Now, the reference is to family models closely linked to cultural stereotypes and or fideistic precepts that affect the very structure of parental relation, gender roles, and family relationship, multiple family unions, marriage, child, early and forced marriage, and so on and so forth. In Italy, for instance, the validity of marriage celebrated in the sky. The comparison in this respect offers a very interesting lens. While revealing a significant proliferation of different family models, it shows how the heterosexual union based on marriage still represents by far the most widespread family archetype. There is more. In analysis of the case law, show how, apart from the regulatory data, a kind of two-way circulation of models that is activated from practice governed by private autonomy to national courts, from national courts to European courts, and from this back to national courts. This triggers a process of harmonization of legal system that it is in many ways more significant than that promoted by institutional legislative or merely doctrinal legislative means, and that also overcomes way attempts to identify soft law as possible harmonization instrument, as it happened, as it was the case for the principle of European family law. Now, it is impossible to give an exhaustive account of this complexity. To test my hypothesis, I shall therefore only deal with the relationship between marriage, a very classic topic, marriage and registered partnership. As known, the archetype of family has been backed up by a changing archipelago of new families, unregistered respective unions, both heterosexual and homosexual, subject to conventional determination. It has civil union, civil solidarity pacts, cooptation contract, partnership agreement, and so on. And marriage equality, the principle of marriage equality between persons of the same sex. On this basis, each legal system has introduced its own rules, resulting in a system that at times includes significant convergences, but also far-reaching divergences. All of these while respecting, as the European Court observed, the effective protection of family life under the famous Article 8 of the European Convention on Human Rights. So that, without prejudice to the competence of individual states, any capricious invasion into family life is forbidden unless it is justified by overriding interest and, in any case, in accordance with a principle, as everybody knows, of proportionality. The right to the recognition of emotional ties could be summed up as the safeguarding of any social structure capable of developing the personality of its members. That is to say, the concept of family today overcomes the barrier of formality and or legitimacy of effective relation by including in its corners both heterosexual monogamous unions founded based on marriage and monoxorial cohabitation, same-sex civil unions, and so on. Therefore, the notion of marriage does not appear to overlap with that of family. It seems to me quite obvious. Having said that, it should be noted immediately that the law did before register significant divergences. Not only less than half the members of the European Union do allow same-sex couples to be united in marriage. Registered partnerships are regulated differently within the European Union. In this package, 9 member states allow all couples, opposite sex or same sex, to register their union. Only 9 member states: Austria, Belgium, Cyprus, Estonia, France, Greece, Malta, and the Netherlands. While only 5 members, Croatia, Italy, Czech Republic, Slovenia, and Hungary, allow only same-sex couples to register the union. 8 member states do not provide for registered partnership, regardless of the sex of the parties. And among these, Bulgaria, Lithuania, Poland, Romania, and so on. In short, at the taxonomy level, we see, just by looking at the taxonomy, that the differences are quite significant. If we look at registered partnership, for instance, it's easy to observe how in those legal systems where they are considered to produce the same effects as marriage, the lawmaker has no longer provided their regulation. Such was the case in Spain, where the introduction of same-sex marriage has meant that there is no longer a reason to maintain the civil union model after, indeed, the promulgation of Law 13 and 15, 2005. The Supreme Court, in its judgment, is quite an old judgment, made it clear that the law, by increasing the flexible nature of the marriage institution, made distinct but assimilable forms of it superfluous. Given the consistency of the legal framework, it is understandable how, especially in relation to same-sex marriage, the risk of limping status is a very high risk. The problem arises especially when 2 persons of the same sex married in a member state, or better, married in a member state, and then they ask for the transcription of such marriage in another member state where same-sex marriage are not allowed. Here too, there are big differences, since, for instance, for the Italian judges, this is quite in 2016, for the Italian judges, same-sex marriage can be legalized. We have Vampiro, and the Vampiro threat, as in the context of the European Union, has led most member states to adopt forms, albeit diversified, of the same-sex couples recognition that has led to a kind of asymmetrical situation in several respects. On the one hand, the introduction of registered partnership only for same-sex couples, the possibility of marriage remaining the prerogative of heterosexual couples, is in line with the case law of the European Court of Human Rights. As known in Oliari versus Italy, the judge recognized same-sex partners' right to private and family life within the framework they articulated, without imposing on the state the duty to introduce a law on same-sex marriage instead of regulating forms of registered partnership. partnerships that, being subject to a logic of separate but equal, seems to cast some shadow on the way to interpret the principle of non-discrimination. On the other hand, where the discipline of marriage has been innovated and at the same time the model of registered partnership has been kept unchanged without extending it to unions between persons of the opposite sex, no doubt that again arises the question of equal treatment between heterosexual and couples and homosexual one. With respect to the first problem, at present, does not seem easy to identify clear perspective for further development. With reference to Italy, it is of particular significance on the issue of the proscription of same-sex marriages celebrated abroad. The ruling of Corte Cassazione in 2018, where the judge decided that same-sex marriage celebrated abroad between an Italian citizen and a foreigner cannot be registered in Italy, considering its legal recognition as a registered partnership, the only one admissible, acceptable. Here, as we can see, the judges, what they do, they end up operating a sort of downgrade of the union. And once again, this raises many doubts in terms of respect for the person and his, her choices. On this topic, more innovative and challenging are some recent case law developments related to the issue of equal treatment for heterosexual couples with respect to accept to registered partnership. These are developments that make clear, let me say, the dual circulation of models refers earlier. Between the end of 2017 and mid 2019, Austria and the United Kingdom have recognized unequal treatment for heterosexual couples when excluding them from the possibility of registering their union. Austria, by adopting the Eingetragene Partnerschaft, had allowed same-sex couples to register their partnership since 2010. Subsequently, the regulation of registered partnership in Austria underwent several modifications to make it increasingly similar to marriage in terms of rights and, of course, protection. Now, in 2012, the Austrian Constitutional Court declared the unconstitutionality of some rule of the law based on the unequal treatment between registered partnership and marriage with respect to the celebration of formalities. And 2 years later, declare unconstitutional the prohibition placed on registered partners with respect to adoption, whether joint or subsequent, has a further development, or better had further development, when an heterosexual couple, Helga Ratzenbuch and Martin Seidel, applied for the registration of their union, and after that, having received and challenged the decision of refusal, brought legal action before the European Court of Human Rights. Now, on October 2017, the court, in deciding the case, ruled that the Austrian law on registered partnership did not violate the European Convention on Human Rights when it precluded access to the union to the registered union for the heterosexual couples. But what happened? What happened? It happens that on 4th December of the same year, the Verfassungsgerichtshof, despite the decision, early ruling of the court, of the European Court, decided on an appeal by a couple of Austrian female citizens who had previously entered into a registered partnership and who had been denied a marriage permit. The judgment recognized that discrimination against same-sex couples violates the principle of equality of all citizens before the law, principle established in Article 7 of the Austrian Federal Constitution. And just to show how works the circulation of model, as a consequence of that, Austria became the first member state to introduce same-sex marriage, following the statement of a constitutional court that refused the principle of the functional equivalence of models. At the same time, and currently, the same ruling recognized that everyone, regardless of their sex, have the right to access the institution of a registered partnership. This was also the case in the United Kingdom, where the equal civil partnership movement had sparked a lively debate on the issue. The story originates from the case of two young heterosexuals in 2014, Seinfeld and Kayden, who had a personal opposition to the institution of marriage. Their application to register the union was rejected for the reason that the parties did not meet the gender identity requirement as prescribed in the Civil Partnership Act of 2004. The court of first and second instance did not recognize the application, and the appeal failed on a very narrow basis, with the judge ruling 2-1 against Rebecca and Charles. All three judges agreed that they were being treated differently because of their sexual orientation, and that this affects their private life and family. All this rejected the judges the argument that they could just get them. All three judges emphasized that the government couldn't maintain the status quo for much longer. Not so the United Kingdom Supreme Court, which in 2018 recognized the couple's claim as well-founded, making out a clear inequality treatment for heterosexual couples. Judge here reversed what the judge of the Court of Appeal had said. The decision, the final decision, was based on the fact that English lawmakers, with the introduction of the Married Same-Sex Couple Act should have repealed Civil Partnership Act or provided for its extension to heterosexual couples. At issue for the judge was the violation of Section 4 of Human Rights Act, of Article 4 section of the Human Rights Act, the 1998, as well as the combined provision of Article 8 and 14 of the European Convention on Human Rights. Now, it's interesting to note that the Supreme Court, unable to proceed in the abrogative sense, firmly indicated to the government the need to overcome current discrimination in England and Wales by way of a reform of the registered partnership, which then actually happened in 2019 with the enactment of the Civil Partnership, Marriages and Death Registration Act. The Supreme Court decision, as everybody knows, has only impact directly on England and Wales. But here again, it's a question of model. In 2012 and 20, the Marriage, Same-Sex Couples and Civil Partnership Act was amended in Ireland to allow also heterosexual couples to enter into registered partnership. And always in 2020, the Scottish Parliament passed the Civil Partnership Act, which chose a law opposite sex couples to register their partnership in Scotland. The evidence coming from the case law is plain. On the one hand, the marriage model, the mariage pour tous, progressively tends fund on the assumption of the equality of couples and the dignity of the person involved. On the other hand, I would say in parallel, a model of cohabitation recognized as more flexible than marriage, namely registered partnership, is gained momentum and of course must be recognized. All couples, irrespective of sexual orientation, it fulfills a new and specific social function and responds to needs that are not only contingent, but also express, reflect values and culture. But, as I mentioned earlier, in this context, a key role has been played by courts, and by courts they activate a kind of circulation of models that forces lawmakers to change direction. The extreme difficulty of working out a common regulatory framework is then evident in the field of family law. Precisely because the family structures is rooted in the peculiarity of every community structure, the family, as already mentioned, embodies the main space for claiming diversified plurality of typologies, articulated on differentiated logics and on the sinuous interaction between biological ties, affective relation, religious archetypes, and social bonds, differently interwoven by the solid web of local tradition and national culture. Yet, it is precisely on the basis of the multifaceted differences between national law and the sphere of family law that a progressive erosion of the hegemony served member states seems to emerge through the increasing and penetrating action of the European Union. Although the idea of drafting a common European family law has been more concretely backed up by a process of standardization, harmonization of private international law, some of the effects of the legislation enacted in terms of individual rights reverberate also at the level of substantive law, contributing on the one hand to inaugurating a new season of family institution in Europe, which is that of the family so-called without a frontier. And seems to me, on the other hand, to setting up a system not entirely consistent with the objective of a material harmonization that effectively guarantees the fundamental requirements of the family as they are emerging from the different national realities. It is the case of the adoption of a disorganized and mediated regulation of certain legal aspects of family and or personal relationship through policy, through intervention on the safeguarding of individual subjective position, such as those introduced by the regulation gradually promulgated on the recognition of judgment in matrimonial matters, including those on parental responsibility, maintenance obligation, and on inheritance. One example of this is the EU Commission proposal for regulation on the recognition of the parenthood of LGBT plus couples and the introduction of a European certificate in parenthood aimed at a certain parental status in all European states, of course. And in its resolution, also the 2021, the European Parliament expressed its deepest concern regarding the discrimination suffered by rainbow family, as we have heard, and their children in the European Union, and insist that the European Union needs to take a common approach to the recognition of same-sex marriages and partnerships. The Parliament has a further call on the Commission to propose a legislative intervention requiring all member states to recognize, for the purposes of national law, the adult's position on a birth certificate issued in another member state as the legal parents of the child, regardless of the legal sex or the marital status of the adults. Now, I am concluding, nor can we fail to notice how the expansive action of European bodies is evident, of course, and is extending. And not only through derived sources, such as the regulation, but also through soft law instruments. Let us think, for instance, to the Council of Europe guidelines concerning the policies to support positive parenting and the appropriate parenting style to be adopted towards the child. Now, and I am at the end of this reflection, it seems to me that, as far as family is concerned, more than a regulation aimed at imposing a kind of harmonization or standardization, the system of competition between solutions provided at the level of individual legal system could be a real, a real alternative to the traditional harmonization process guided by the top. Thank you very much.
Thank you very much, Virginia, for your fascinating reflections, also from a very general perspective of the way the EU law might manage or deal with these new realities. So thank you very much. The next speaker is Professor Ana Isabel Berrocal of the University of Madrid. The title of her presentation is The Protection of Children and Adolescents in the Digital Environment in the European Union. Ana, the floor is yours. And thank you very much for accepting to speak today.
Many thanks to the organization of the webinar for letting me participate in it. Many thanks to
Ana, excuse me, Ana, I can't see you. Perhaps I can hear you, but I can't see you.
Please switch on the camera.
Yeah, the camera is perhaps off.
Yes. Now?
No. Oh, yes.
Yes, now?
Yes.
Oh,
no.
very
Yes.
nice.
Sorry.
Thank you.
Good morning. Many thanks of the organization of the webinar for letting me participate tonight. Many thanks to the professor of Civil Law at UNED, Francisco Javier Jiménez Muñoz. Also, many thanks to the other speakers who are taking part and for listening to me. My study is going to center on the impact that new technologies have on minors, especially with the emergence of artificial intelligence. To do so, we will analyze European data protection and artificial intelligence regulation. My presentation is entitled The Protection of Children and Adolescents in the Digital Environment in the European Union. Please excuse me for having to leave after my presentation, as I have to teach a class in the law degree. As an introduction, the digital era we understood as the time in which the internet represents an increase in much faster and more intense communication. Has been for minors and common place in which the internet has represented a space where they can demand a behavior and also a way of learning. This space has increased considerably with the health crisis, in which minors have had to carry out both leisure and education throughout the networks. This has led to minors who are already accustomed to performing numerous actions through technology, finding themselves immersed in a large digital environment. These so-called digital native, who are skilled in handling information and communication technologies, see their rights violated and lack sufficient guaranteed, and many of them are clearly violated. In the digital age, access to the internet and the use of mobile application has become an essential part of people's lives. including children and adolescents. The benefits of this access and undeniable, allowing them access to information, knowledge, with existent and important opportunities for education and learning when able to access education resources that facilitates, among others, the right of the freedom of expression, freedom of thought, or freedom of conscience. Likewise, the internet rights their social environment by facilitation and promotion communication with peers, and therefore their social participation favoring their personal development. The use of the social networks also allows them to interact with their friends, share experience, and participate in diverse environments, fostering their emotional development and evolution together with an enrichment of their social environment. As this states their personal identity as fundamental their social identity development, and consequently their digital identity as well in the sense of who they present themselves and behave and social network and platform where they are in contact with the peers. The risks and dangers they must face are already exist with being transferred to digital world. They are more difficult to protect against. Thus, addiction, cyberbullying, exposure to inappropriate content, and even social difference between those who have more economic resources for digital effects are, among others, some of the problems they encounter with a much appropriate for regulation framework tools and any other instrument for this protection. Prevents the rise of access for leading to a problem that affects their development in all its facets. It is there essential to balance the rights of children and adolescents to access internet and information with their rights to health and safety, all under the principle of the best interest of the children. The need for balance between the rights of children and adolescents to access to internet information with the right to health and safety has been the subject of the general observation of the United Nations Committee of the Rights of the Child adopted in 2021 with focus in the rights of the children in relation to the digital environment, offering guidelines to state parts to implement the rights of the children and adolescents in the digital environment. The general observation base there's rights of 4 general principles. No discrimination, so that state parts ensure that all children have equitable and effective access to the digital environment in a way that is beneficial to them, the best interest of the child, the right to life, survival and development with state parts taking all appropriate measures to protect children from all theater to the rights to life, survival and development. In this context, children and adolescents life immersed in digital world where connecting is content and unlimited. From a very young age, there are exposed and even increased variety of technology, smartphones, tablets, computer, and una variety of the lines platforms, social networks, video games, and streaming service. While this advance opened the door to new forms of the learning, education, and educational and social opportunity, they also bring with them significant challenges in the child protection. New technology has revolutionized child in ways that a generation will have seemed like is efficient. Today, children and adolescents have the ability to learn at their own pace and explore in infamous oceans the information. However, the connectivity to which they have access also exposes them to considerable risks such as cyberbullying, exposed to inappropriate content, and the erosion of their privacy. A fundamental challenge that we cannot ignore is privacy and data security. Minors often behind aware of this share a significant amount of personal information on the internet. Various platforms and applications collect data that can often be used for commercial purposes, often without the parents themselves weighing proper information or having their consent in a clear manner. The United Nations Human Rights Council, its resolution, information protection and enjoyment of human rights on the internet, states that the rights of the society should be protected on the internet. Invoking Article 20 of the Universal Declaration of Human Rights and the International Convention of Civil and Political Rights. However, digital integration must also be related to a previous social integration. It's necessary to take into account minors who are in a vulnerable situation and the need for public entities to adopt a series of tools and instruments that really the legislator has previously contemplated for their protection. In 2027, UNICEF, in the report Children in the Digital World, referred to the dangers in the sense of content, conduct, and contact features. The protection of minors in cyberspace is priority that has been addressed through a set of regulation and laws both in Spain and international. In Spain, the Spanish Constitution in el Article 18 refers to the protection of personal data as a fundamental right. This article provides a solid basis for the regulation that protects the personal data of minors in Spain. For its part, in Article 39, the Spanish Constitution established that the public powers will ensure to the social, economic, and legal protection of the family, and that same public powers will ensure the protection of children, equal before the law, regardless of their affiliation, and that parents must provide assistance of all kind to the children they have both with outside the marital framework during the time in which they are minors, and in other cases in which the legislation contemplates. In addition to the minor having the applicable international protection, Article 154, the Civil Code, in development of the child process, established the obligation of parents to look after their children both in a physical and digital environment. There is talk of positive parenting, private as well as the press of the violent behavior in this family environment, especially in this that you have to look after the children. And in the basic of parental control, the Supreme Court Criminal Division, the 10 December 15, has considered lawful the access to account open with the minor daughter and on a social network by the mother with their consent, without her consent, due to the suspicion that the could be the victim of crime of the cyberbullying or cybergroom. Are we the court that we are talking about a mother who is a holder of parental authority, conceived not a power but unprotected function with respect to the minor? ECC, who assess that account, is the face of clear sin that a presumably criminal activity was taking place in ways the victimization of the daughter could not be excluded. On one of the purpose of the organic law 21 is Article 3, letter im, is to establish the protocols, mechanics, and other measures necessary for the creation of safe, good treatment, and inclusive environment for children in all areas developed in the law in which the minor develop his or her life. A safe environment is understood to be one the respect rights of children and promote protective psychical, psychological, and social environment, including the digital environment. Article 33 establishes training in digital rights, security, and responsibilities in such a way that public administration will guarantee to full integration of students in digital society and the learning of the use of digital media that is safe and respectful of human dignity, constitution values, fundamental rights, and particularly with respect and guarantee of personal and family privacy, and the protection of personal data in accord with the provision of the law 2 December 2013 on the protection of personal data and guarantees of digital rights. Especially public administration will promote to appropriate use of the internet within all training states. Finally, the right to image is contemplated in this law with reinforcement of respect for the honor, privacy, and image of the minor who has been a victim of the violence, and as well as the relative considering this right even beyond to that of the minor. Article 3, letter N, protects the image minor from birth until after their death. After the 2021 ordinance law, I elaborate a strategy to eradicate violence. It has been developed covers the period 2023 and 2023 and continue 5 strategic areas. Pardon. And this strategy contains also a series of principles of good treatment, survival and full on integral development, best interests, equality and non-discrimination, participation and protagonism, principle of universal accessibility, due diligence, multidisciplinarity, transversality, and intersectionality. Principle government to action of the public administration. And the following definition, I include children and adolescents respecting the scope of application of the comments on the rights of the child. This category includes all persons under 18 years of age. Violence is understood to be any action, omission, or negligent treatment that deprives a child or adolescent of their rights and well-being that threaten and interferes with their other psychological, or social development, regardless of forms and means of commission, including to carry it out through information and communication technology. A situation of the vulnerability, children and adolescents may find themselves in situations that create or increase their vulnerability to violence. This situation include having a disability within 0 and 3 years old, when and diverse racial, ethnic, or national origins, being economical disadvantage, belonging to the LGBTQ buying an application for a beneficiary or international or temporary protection and linked parental care or buying of rates of losing needs. Freelance or data service, there are systems that guarantees respect for an effective relation of the rights of the children and adolescents at the highest possible level, taking into account, in particular, the principles of participation, no discrimination, best interest, and survival and development. For its part, the Justice Commission of Congress approved this Monday the opinion of the Organ Law Project measures regarding to efficiency of the public justice service and collective action for the protection and defense of the rights and interests of consumer and user, which has included the specialization of courts and users in violence against children and adolescents. Continuing with our national regulation, the Organic Law 2015 of July 22 modifies the system of protection to children and adolescents, modifies la Organic Law 1996, affecting Article 2 regarding the best interest of the child, in which is established as paramount and must be subject to exception. In international ODAs formulates a series of the action to achieve specific and determinate objectives that are part of the 2030 Agenda for Sustainable Development. They consist of a total of the 5 objectives, of which we consider that some of the can applicate to the case under study. Their purpose must be achieved by 2030. The white paper on artificial intelligence and European approach to excellence and trust of 19 February 2020, for example, mention some elements that may be rights for minors, as a smartwatch, which in themselves do not constitute endangered products, but thought which it may be possible to access the localization of minor with the consequent rights to the minor. Successively to the chart of digital rights of children and adolescents of ANAR Foundation, the Minister of the Economy, Affairs and Digital Transformation of Government Spain, and through a committee expert, drafts the Charter of Digital Rights, which is submitted for public consultation and whose articles contains a specific provision within the rights of equality provision, then on the protection of minors in the digital environment. This text reorganize a story of the rights, which include the right of minor. In Europe, as we approved the regulament 16 data protection, general data protection regulation, also recognize margin of the maneuver for member states to specify the rules, including in relation to the process of special categories the data, and with respect the certain circumstances relative to specific process situation, including those relating to the process of personal data, the conditions of the legality of data processing. To the end, in Spain, organic law sank the December 2018 on the protection of personal data and guarantees of digital rights was approved in Spain, which came into force in 7 December 2016. Whereas analyze the data protection regulation and artificial intelligence, we think is appropriate to refer to the types of online violence, like sexting with consentment that is not with the same. The term sexting is the result of the contradiction of sex and testing, sending messages, and used to refer to the exchange of messaging or material online. Is definite are conduct or practices within adolescents consisting of the production of any type of digital images in which minors appears naked or semi-naked, and their transmission to other minors either through mobile phones or for email or by making them able to 3 parts via internet. Sextortion. The term sextortion is a contradiction of the word sex and extortion. Its name indicates it's blackmail or threat to public audiovisual content or personal sexual information. In this case of the child or adolescent, thus we enter to online dimension on blackmail that can last hours, months, or years, and can be carried out by a person now or now to the victim. In addition, it's very unlikely that the person who suffers from is will ask for help, either because they feel ashamed, guilty, or are afraid that their intimate material will be spread. In most cases, the child fears that their family and friends will discover that they have shared sexual material. Online violence in the couple of partners. The violence is defined as the set of repeated behaviors that aim to control, undermine, or cause harm to the partner or partner. So it's very likely that whoever suffers of course or cause violence in the physical world will also do so in the virtual world. Cyberbullying is a violence with peers that consists of harassment towards a victim through messages, images, videos, or comments, all of them with the intention of harming, insulting, humiliating, or demeaning. I like bullying. There is no direct face-to-face contact, and is lasts longer because the content goes viral throughout its dissemination, losing control over it. Cyberbullying can occur with children for different schools outside of school hours and can stand identified over time. On the content is public digital, it can be reproduced and reproduced infinitely. Happy slapping is a term that originates in the United Kingdom and has spread around the world in recent years. It defines as violence that consists of the recording of assault, whether physical, verbal, or sexual, towards a person with is sequentially disseminated through communication technologies. The assault can be published on their website or social network or conventional and mobile phone, etc. Online grooming or cyber deception. Online grooming is crime in which an adult electronic contacts a child or adolescent gradually gain their trust with the purpose of the involving them in sexual activity. This can range from talking about sex and obtain sexual material to maintain a sexual encounter. Even when this yacht is not archived, all material as aimed and archived are also considered only grooming. Involuntary exposure to sexual and or violence material. Girls, boys, and adolescents have unlimited access to the internet. So material with a sexual and or violent component is available to any who suffer the words. Without intending to, they can be exposed to content that is not appropriate for their age, which can affect their development and their understanding of personal relationships. This is voluntary exposure to sexual and or violent material. Important is platforms that explains on encourage self-harms oversight that promoted eating disorders such as anorexia or bulimia. These include explanations of how to coach suicide technique, how to overcoming the desire to eat, keeping all this behavior secret, etc. Sharenting. The term sharenting comes from the English words share and parents. It's a really common practice for the mother and fathers to constantly and publicly expose to life of the daughter and son in the internet. Birthdays, activities, at first it may seem like a harmless habit, which we are aware of the consequence it can have in the lives of the girls and boys. The digital footprint and the trial we live behind when virus the internet is a place where we cannot erase it. For children, this footprint is created at incredibly early age, that to the publication of personal information by parents. Considering this above, the judgment of the Provisional Court of Pontevedra for June 15 provides in the regard that even though where are the line with a case of separate parents in which the custody of the minor child has been awarded to the mother, the divorce judgment has agreed that both parents retain parental authority. Therefore, if Mr. Adrian intends to publish photos of the minors shown in social network, he must first obtain the consentment of the appellant parent, and if she objects, he may resort to the judicial proceedings in order to obtain her authorization. Also, in this line, the judgment of the Provincial Court of Lugo, 15 February 17, signed in the absence of evidence that access to accounts was public, and the fact that there is not recording of anything other than the possibility of access to photographs taken by the grandmother to her closest circle of family and friends. Among one Burger, the mother and father of the child, it cannot be understood to the privacy and the image of the minors could have been violated because the grandmother behavior conforms to the most social use of the publishing news and photographies of the family natural among those closest to her. Respect data protection regulation, Article 1 establishes the purpose of the regulation as the protection of fundamental rights and freedom of natural person, in particular in relation to the protection of personal, en este caso, data. Personal data is defined in Article 4 as any information relative to an identity and identifiable natural person, the data object, an identifiable natural person shall be considered to be any person whose identity can be determined directly or indirectly, in particular by reference to an identifier such as name, an identification number, localization data and online identification, or the other or more factor specific to the psychology, genetic, mental, economic, cultural, or social identity of the person. This reglement is developing in 6 principles established in Capel 2. Legality, loyalty, and transparency. Limitation of the purpose, that minimization, accuracy, limitation of the conservation data period 6 years, integrity and confidentiality. The same capital established to the condition for the legitimate protection of personal data. Capital 3 established to the set of rights the assistant data javits, the obligation to guarantee them and to implement effective mechanics for the exercise of this. In particular, the rights of the transparency, information, affects ratification, deletion, limitation, opposition, portability, or mass that's great importance in certain artificial intelligence application, such as the rights that citizens have in relation to automatic decision making. Capel 4 established the model of responsibility compliance based on accountability or proactive responsibility, and whose guiding elements are the identification of the responsibility in the treatment, the analysis of the risk for rights and freedoms, the study of the needs and proportional of the treatment operation with respect to this purpose, develop or measure for risk management, privacy measures by default or by design, security measure, incident management. It included the summary. Capel 5 established the condition for the exclusion of transference of personal data to third countries or international organizations. On a brief analysis of data protection in general has been carried out, is in time refers to consent. In Spain, el consent for minors is 14. Minors 14 and minors within 14 and 20 years old, this may with consent for the use of their personal data by self. Minors within 4 and 20 years old, they will consentment for use personal data is versus parents or guardianships. Now, where analysis to the artificial intelligence regulation and its impact on the children, we must make a brief reference to the responsibility of parents, guardianships, and not university education centers. Article 1803, second section of the Civil Code established the parents' or responsibility for damage caused by children under their care. The basic of the parents' liability for the harmful acts of their children under care informed in the culpa in vigilando or in educando of parents and themselves. Signs and content of parental authority is to have them in the company, educate them, and provide with a comprehensive education. Article 154. Now, with respect to the criminal liability of minors, Article 20 of the Criminal Code set the criminal age at 18 years. So that minor under that age will not be criminal liable according to the state code. No, according will parent with civil liable for criminal act committed by their minor children in accordance with the provision of the aforementioned legal body. Organic Law 20,000 of January 2 is the one that regulates the criminal liability of minors under 8 years of age. Thus, Article 3 of the Organic Law provides that when the author of the act mentioned if previous articles is under 14 years of age, he will not be held liable according to this law, but rather the provision of the regulation on the protection of minor provides for in the Civil Code, and other current provision will be applied to him. On the other hand, Article 61, Section 3 of said legal bodies establish that when the person responsible for the act committed is minor under 8 years of age, these parent tutors will be jointly liable with him for the damage and loss causes in that order. When these have no favorables the conduct of the minor with intense or gross negligence, their liability will be moderate for the judge according to the case. Thus, they will be criminal liable for the crimes of offenses committed by minors over 14 years of age according to the organic law, and likewise is specific how will be civil liable. And reference to the intelligence regulation is a technology that has experienced spectacular progress in a short time, that thanks to the combination of the factors such as big data, blockchains, the cloud, the Internet of Things, robotics, and virtual reality. Also, artificial intelligence is not a recent invention. It's oriented back more than 15 years. Its current impact in enormous and affects almost all areas of life. In combination of factors such as advance in computing power, the ability of high amount of data, and new algorithms have allowed great achievements in intelligent systems in recent years. What defines all systems is the ability to process data and information in a way that resembles intelligent behavior and generally covers aspects of reason, learning, creativity, of ability to prediction or plan. Is therefore a set of technology that allow a computer systems to simulate characteristics that are typical of human intelligence. Is this way certain activities that until now were exclusive linking to man without process such as design making are automated. Artificial intelligence systems are capable of adapting their behavior to a certain extent, analysis to the effect of previous action and working autonomously. There are information processing technologies that integrate model and algorithms capable of the learning and performing cognitive tasks, giving rise to results such as prediction as decision making in physical and virtual environment. Artificial intelligence is clearly related to big data. It needs to developing its functionalities, science fits of the large amount of data collection to train machine learning models and make decisions based on patterns and correlation. These synergies allows artificial intelligence to perform tasks such as natural language processing, computer vision, and predictive decision making with a high degree of precision. Blockchain technology also plays important roles in this ecosystem by liberating the security and mutability provided by blockchain. Both big data and artificial intelligence can ensure data integrity, which is essential in critical applications such as digital identity authentication and cryptography, key management, strengthening security and digital communication and tracing. This cybersecurity is another relevant issue in this area. Key elements of the intelligence artificial: machine-based system, autonomy, human supervisor, outputs. The system process input data to generate outputs such as prediction, content, recommendation, or decision. Main exclusion: system uses exclusively for military defense or national security purpose, as well as does patch into service solely for extensive research and development purpose. The chief testing or development activity relating to an intelligence system or model before their introduction of the market or commissioning. Natural person using artificial intelligence system in the exercise of the purely personal, no professional activity. The artificial intelligence regulation following a risk-based approach to the legal intervention is tailored to the specific level of risks: minimal risks, limited risks, or high risks. In established risks, the artificial intelligence regulation establishes an absolute prohibition for several practices to inacceptable risks. High risks, the regulation artificial intelligence classifies as high risk certain systems that has significant risks of the harm to health, security, or fundamental risks. Limited risks, specific transparency requirements applicable to certain system intelligence artificial, for example, where there is a clear risk of manipulation. Thought the use of thoughts. User must we are aware that an intelligent with an intelligence system, minimum errors, minimum risks. All other intelligent system can be developed and used in complicated with applied law without additional obligation.
Anna,
See,
excuse me,
yes.
Anna, we
May
are running
volunteers-
late, so please, might you come to your conclusion? Thank you.
Conclusion. The risks of using intelligence of minors, artificial intelligence for minors, privacy and security, dependence and overrust, inappropriate content or misinformation, the role of parents and educators, privacy and security education, setting time limits, active supervision and participation. Sample to facilitate the roles of families, the agency, Spanish agency protects that, while intensive collaboration with the National Institute of Cybersecurity for analysis of the parental controls and provides to the family the parental control tools and the system, the verified age. The protection of minor internet is one of the priorities, not only at the national level, but also in Europe. The purpose is to prevent uncontrolled access by children to inappropriate content with its service that age verification. The Spain Data Protection Agency has a set of principles that should guide these systems. Age verification is a system designed to protect minors for inappropriate content of the internet, with as is maintains what be accessible to those people who freely decide to consult it, provide that they meet the established age condition. Sample for finish. Boundaries Digital and Security are working on new connection system that brought minor for inappropriate content with the development of an application that use facial biometric and in artificial intelligence. The Germany Commission for the Protection of Minors in the media has approved the use of three age verification system using artificial intelligence tools to prevent minors for being exposed to harmful content. The German public body is responsible for monitoring the protection of minors on national private television and the internet. The intelligent artificial system approved for the German state body use machine learning methods to analyze a person age based in certain biometric parameters. Thank you very much.
Thank you very much, Anna. Since we are running very late, I give immediately the floor to Abigail Quesada, Digital Parenting. Abigail, are you here? Yes. Abigail Quesada. I see.
Abigail, you have to switch on your microphone.
Okay. Now we can see, but not hear you.
Okay, thank you very much.
No, sorry, Abigail. Your voice is a bit low. Can you perhaps your microphone is not perhaps working properly, or the degree of the sound? Well,
No,
it is still
very
quite
low.
low. Yeah. No. You have to increase the volume of your voice.
If I speak like this, do you hear me, or still
Mm.
not loud enough?
Well, I can speak for myself. I can't hear
Yes.
you very well, but perhaps Francisco, I don't know, perhaps it's
That's it. The volume is very low.
Mm.
I don't know. I can try to connect with another device. Better, I'm so
Try again.
Do you hear now?
Not yet.
No.
No?
Nothing.
No.
Nothing.
Nothing.
Even
Well.
words.
No, and we are
Yeah.
running also very late, so I am a little bit concerned by the.
Perhaps we can.
We can try to solve the problem in the pause, maybe, and
Yeah.
postpone the intervention.
At the
Well,
beginning of the afternoon session, perhaps.
We can make the break right now.
Yeah.
And retake Abigail after the break, if you think
After
it's
the
okay.
break,
I'll try to fix it.
because we should resume at 12:30. It is quite strict.
So we should resume at 12:30, and are we
Yes.
just postponing everyone, or would you like to intervene after Bumbaka at the end? I don't know.
Yes, I think it's the best solution. So, we are going to make the break right
break.
now, and we retake our webinar at 12:30.
Okay, 12:30. Yes.
So 12:30, we come back. Let's try with Abigail after Vito Bumbaka. So
Yes.
Okay.
In this way, she has more time to solve these issues,
yes.
technical issues.
Okay.
Okay.
So
Then
Thank you to
thank-
everyone for
yeah.
joining, and see you in 19 minutes. Bye.
See you later. Thank you very
Thank
much
you.
for
Abi-
joining us.
Abigail,
And stay
sorry.
here.
Abigail, you can, sorry, it's perhaps you have in the speaker, en los altavoces, en el audio, en ajustes, a lo mejor a veces no lo tienes en altavoz. Tú le das en los 3 puntitos que aparecen, no sé si tú ves, pinchas en altavoz, le das a los 3 puntitos y lo pasas de uno a otro.